Court is now in session with your host, Peter Briggs.
Welcome to the Lawyers and Laypeople podcast, a conversation-based podcast featuring interviews with some of Georgia's top lawyers where we, in an easy-to-understand way, answer the questions that are on the minds of you, the layperson. In this podcast, we talk to specialists in a particular field of law to hear directly from them as to what clients typically ask them and what they should be asking. I'm your host, Peter Briggs. I graduated law school in 2006 from Georgia State University here in Atlanta and have been practicing as a lawyer for almost 17 years. I'm a personal injury and bankruptcy attorney as well as a registered mediator. Now, normally I would have a guest, but because today is the practice area we're discussing is Chapter 7 and Chapter 13 individual consumer bankruptcy cases, and this is one of my specialty areas, I've decided to handle this one all by myself. So let me start off by saying, what do I like most about practicing consumer bankruptcy law? You know, there are just some areas of law, like wills or real estate closing, for example. I'm just picking a couple where there's no, you're just kind of moving paper. In this area of law, you really get to provide something for a client, a tangible, immediate relief, and develop a real personal relationship with the client, and provide something for them that's just been weighing on their mind. And, when you can provide them, lead them to the path to get a discharge in their bankruptcy case, there's just a lot of gratitude that comes along with that. So let me start off by explaining, as a consumer, when you go and you have your initial consultation with the bankruptcy lawyer, what really should be discussed and how that should end. And the first thing is, the first goal of your initial consultation should be determined, do you need to file this bankruptcy? I often get calls by people telling me, I'm calling you because I need to file a bankruptcy. Well, that may or may not be true. You got to get to the heart of that in your consultation, because sometimes people think they do, and then they really find out that bankruptcy is not going to provide them with the type of relief they really need. So the first thing you do is you look at, do you have enough debt that can be discharged? So that means you may have debt that is non-dischargeable in your bankruptcy. For example, you might have some very recent income tax debt that is the substantial portion of your debt. Well, filing Chapter 7 is not going to erase that, or student loan debt that is usually non-dischargeable. Or you may just have a very minimal amount of debt that is dischargeable, and that would be your full debt. Let's say it's $5,000. Usually, even if you're unemployed, that probably is not enough to justify filing a bankruptcy, particularly Chapter 7. Then we also look at, you may be judgment proof. This is not an official term. It's essentially comes into play usually with older clients, usually people who are now retired. Maybe their sole income is Social Security, and they have a creditor pursuing them, but they don't really have much in the way of assets. Their income's going to be exempt from a garnishment. So you may say, well, there's really nothing the creditor who's bothering you can get at right now. So do you really want to go through this bankruptcy process? Now, you still may, but that is a consideration you're going to want to look at. Then you're going to also want to say, can you pay your way out of this? So sometimes you may have not a substantial amount of debt, enough debt to justify filing. However, you were unemployed, now you've become employed, and it is possible you can pay your way out of this. And it is also possible you could file the bankruptcy, but you got to weigh the pros and cons and determine if it really is worth it with your new situation on your income status. Also, you maybe only have one or two creditors. So let's say you've just got only a couple creditors, and now the debts themselves are large, but you could potentially work out a deal with that one big creditor or two big creditors. And when you only have a few creditors, you want to make sure you can exhaust the option to work it out outside bankruptcy, where that may not be practical if you have 10 or 15 or 20 creditors. So, and then also you may want to do a wait and see approach. Sometimes people will call me and they're ready to file, and they're 3 months behind on their mortgage, but let's say their mortgage is not up for foreclosure, they're just behind and they're trying to work out a loan modification, and there's no great need to file because it's not up for foreclosure, and that's the only real thing that's bothering them. It may be worth it there may be no great need to rush to file. You may want to wait and see what happens with that mortgage situation, for example. And then one other thing is, a married couple will sometimes come to me and sometimes they think that they both need to file. While it's true that when you're married, the other spouse's income and assets do get factored into the bankruptcy equation in various parts, both spouses do not need to file. They can choose to file, and you may want to file together, but there are instances where only one of the spouse really should file. For example, if you're both on the house and the mortgage, and that's the major problem, you get the automatic stay when you file bankruptcy. You may just say, look, having this second spouse file is not going to do anything for me. I'm going to get the automatic stay anyway from either of us filing, and there's really no point in the second person filing. So let's keep that spouse out of bankruptcy, and then we'll discuss which is the one we want to put in and which is the one we want to leave out. So now let's say we've determined that you do need to or want to file a bankruptcy after going through all that. Now we want to look at Chapter 7 or Chapter 13 bankruptcy, which is the one that makes the most sense. And generally speaking, you're going to want to do a Chapter 7 unless one of these things comes up. So Chapter 7, you're going to want to file that as the liquidation chapter unless you've got one of these things. So the first one is you're ineligible for a discharge in a Chapter 7. I actually just got a call this week by someone who wanted to file a Chapter 7 again. They informed me that they had filed with me before, looked at their file, determined their prior filing was just over 7 years from the date that I was getting this phone call. Well, that person was ineligible to get a discharge because they weren't at the 8-year mark. So at that point, the conversation shifted to, okay, if you want to file a Chapter 7, you're going to have to wait it out another 10 months. Now, what can we do to deal with your creditors in those 10 months? So you just may be ineligible for a discharge. And it's very, very, very rarely makes sense to file a Chapter 7 when you're ineligible for a discharge. Then you may have not enough dischargeable debt for Chapter 7, or you need a repayment plan. What that means is you may have a ton of debt, but 90% of it you're not going to get rid of in a Chapter 7 or 95%. So Chapter 7's not really going to give you a ton of relief. So Chapter 13 would probably make more sense in that instance. Also, in regards to a repayment plan, you may be up for foreclosure and 12 months behind on your mortgage, and the primary thing you're thinking about is how are we going to keep this house? I need a repayment plan to get caught up. Maybe your income was down and that's what led you to get behind, and now you're in a position where your income's much higher, so you can afford to get caught up. That would be an example of Chapter 13 is going to work more to what you want than Chapter 7. Now, you still may want to do a Chapter 7 and then maybe later do a Chapter 13. I know that sounds strange, but that actually is a strategy that makes sense in a lot of instances. But generally speaking, if your debts are primarily secured debts and you're behind on those and you're trying to keep that house, car, those are the kind of things that are more apt to be a Chapter 13 case than a Chapter 7 case. You may have too much income for Chapter 7. So a couple things about this. One is I'll often get calls from people that said, oh, I'm ineligible for Chapter 7 based on my income. That's not a real thing. There is no too much income makes you ineligible as just a matter of law. There is a thing called a means test that they look at, and we factor in your income, factor in your debts. You get certain kind of debts, get certain kind of deductions, others don't. So mortgage is an important debt. Let's say you had child support, that's an important debt. Whereas other things, you just kind of get a baseline, like your food, your clothing, based on your household size, and you get means tested. So if you otherwise would want to file a Chapter 7, but your income is too high and then your allowable expenses, deductions are too low, and therefore you, under the means test, don't qualify for a Chapter 7, or at least based on a presumption, that is the kind of thing that would, I could tell a client, look, there's really no way that the U.S. Trustee's Office is going to allow you to get away with a Chapter 7 discharge based on your income and your debts. So we need to look at Chapter 13. So according to this means test formula, you can really afford a Chapter 13 repayment plan of $1,000 a month. So I know you'd like to do a Chapter 7, and that would be awesome. You'd get rid of $50,000 in unsecured debt, wouldn't have to do a repayment plan, but your income's too high in comparison to your expenses. So that's a key one. And there is an exception to that, which is non-consumer debt. So you can have someone who otherwise would not squeeze into a Chapter 7 based on their income being too high. But if the majority of their debt is for non-consumer purposes, and this comes up sometimes, let's say you have incurred the majority of your debt for a business purpose. You started your business and you gave all these personal guarantees out, and then the business failed, and now you make some decent income, but you've got all these residual debts from the business that you started and failed. There is an exception to get into a Chapter 7, whereas if the majority of your debt was for credit cards or your home mortgage or something, that exact same fact pattern, exact same income, expenses, you would not get into a Chapter 7. So you do have to look at that. And then we have a thing in bankruptcy called exemptions. So essentially the expression is sort of you get a fresh start, not a head start. So, and this will vary by your state, you get to keep a certain amount of stuff, i.e. exempt a certain amount of stuff. So whenever you're filing Chapter 7, or filing a bankruptcy, to determine if Chapter 7 is the right fit, you got to know ahead of time, before you file the case, whether you are at risk for losing anything. Okay, so for that, we got to look at your assets and what you can keep. And we got to determine that ahead of time before you file, whether that's at risk. Now, there are instances where I have filed Chapter 7s with people who knew going in they were going to lose something, but their debt was so substantial that they still wanted to file a Chapter 7 and see something liquidated. So that's not to say you're never going to file a Chapter 7 if you stand to lose something, but you just want to know ahead of time, hey, if I file a Chapter 7, here's what I stand to lose. Compare the risk reward, and that, depending on how much debt you have and what you get rid of and what asset you would lose, you maybe don't want to file a Chapter 7. For example, let's say here in Georgia, we don't get a large homestead exemption. Let's say you just absolutely don't want to move out of your house and you have $200,000 in home equity or $150,000 in home equity. Then I got to tell you, look, if you're going to file a Chapter 7, you're at great risk of losing your house. So if you want to keep your house and do a bankruptcy, you're going to have to do a Chapter 13 repayment plan. So those are all the things you look at. Now, the third goal is, should we file now or wait? Okay, so there are times where, okay, we've determined Chapter 7 makes sense, we determined there's enough debt, and client's ready to go, but there may be instances where all that makes perfect sense, but you need to wait. Most common example is tax debt. A lot of people don't realize income tax debt can be dischargeable in certain instances in Chapter 7 bankruptcy. I have had people contact me with a large amount of income tax debt that was close to being eligible for a discharge. And by that, I mean, 6 months or less. And the conversation I've had to have with them is, do you realize you can get rid of an extra $30,000, $40,000 in tax debt if you hold off on filing this bankruptcy another 4 months? And now they may have to pick their poison. They may be in a scenario where their house is also up for foreclosure or something where they need to immediately file. But you've got to be aware of what's going on, what could change on the dischargeability scale. Should I wait or should I not? And again, with tax debt, that often comes up that you may want to wait. And this will, of course, depend on how old the tax debt is, how close it's being discharged, what is the amount of the tax debt. You got to just factor all this. And as the client, you just got to know, have your attorney let you know, and then you can do the risk reward yourself. Transfers to third parties or preferences. So sometimes people have given property away to family members in the past year, nefarious reasons or not nefarious reasons. They've also paid a large debt to a creditor that's a family member, again, not nefarious reasons, or a friend, or maybe someone who's not even any of the above, an institutional creditor. There are rules, we call them preferences, or gift transfers, where you could either be threatening your discharge or threatening that third party by having a trustee come and try to collect against them for things you've given away in the past year or 2 years. This will depend on a variety of factors. So we have to look at what you've given away recently, or paid creditors, and determine, is any of that at risk to that third party or potentially risking your own discharge? And then we might say, okay, we got to wait. So those are deadlines that are not really arguable. They're set by law dates. So you've just got to get your dates. You don't approximate, you get the exact dates and determine when, maybe I need to hold off filing this case 2 months. So then income changes. This can work both ways. You could be eligible for the means test now because you had a large period of unemployment in the last 6 months, or the converse, you're ineligible now because you just got laid off. So, and some sort of income changes could impact, maybe you do want to do a Chapter 13, but you can't afford it now. However, you're in line to get a raise. But that raise is 6 weeks away. So essentially, your income fluctuation could change how this thing works in a variety of factors. Also, wait for a foreclosure date would be another one. I've touched on this earlier, which is, sometimes you're up for foreclosure, but the foreclosure date, and this will vary by your state law. In Georgia, we have non-judicial foreclosure. It goes pretty quick from your notice to the sale date, but in some states it can take a while. So essentially, you have to determine based on the foreclosure date. This is just one example. Okay, I need to file by this day. All right, and that day is 6 weeks away. Well, you could file now, but maybe you want to wait 5 weeks to file because maybe they'll cancel the foreclosure sale, for example. So that's just another factor you want to consider is there immediacy to your filing. All right, and then now we got to figure out how we're going to pay for this. So Chapter 7 fees, attorney's fees are pretty much paid up front before you file the case. Essentially, the attorney pretty much estimates how much work time is going to be put in. Some cases are more complex than others. Like, for example, I mentioned earlier, what if you have some tax debt I got to look at to determine if it's dischargeable? I've got to run an analysis. That is more work than a case with just unsecured credit card debt. So essentially, you're going to get, in a typical case, quoted a flat fee. And you're also going to have a court filing fee, which currently is $338. And some miscellaneous fees, like you have to take an online consumer credit counseling course. But you've got to be able to pay for all this before the case is filed. Now, there are instances where you could have fees incurred after you file in Chapter 7. That's typically if you get sued for an adversary proceeding or have some just additional work like a redemption motion. But for the most part, your Chapter 7 fees are kind of done and paid for by the time you file your bankruptcy, but you got to come up with the money to pay that. Chapter 13 is more about, it's a repayment plan. You do have to pay a court filing fee of $313 before you file the case, and then this is really going to vary wildly by attorney how much, if any, they're going to require for upfront payment in a Chapter 13. But usually you're going to have to come up with some upfront attorney's fees in Chapter 13 bankruptcy. And then the last thing is you just got to have an understanding of the case as far as redemption, reaffirmation, things like that, meaning you may want to redeem your car if you're filing Chapter 7. I'm just giving one example. You may want to redeem your car in Chapter 7, which means purchase it at the fair market value. So let's say you have a car that you owe $5,000 on and it's worth $1,000. You can buy that in Chapter 7 for $1,000. So you want to know ahead of time with your attorney, what is the strategy? Are we going to do that? Well, if you're going to do that, now you need to discuss how are you going to come up with the $1,000. Additionally, you may invoke a strategy where you don't file the redemption motion until 2 or 3 months into your case. You use the automatic stay during that time. So you don't need to come up with $1,000 right away to redeem that vehicle. So, and let's just quickly discuss the Chapter 7 process from beginning to end. Basically, the way that works is you file a case. When the attorney presses go, files it electronically with the court system, you instantly get a case number. You are in bankruptcy. You have the automatic stay. You have that cocoon of protection. You will find out about 24 to 48 hours later when your court date is. Your court date will be about 5 weeks later. That is called your creditor meeting. You will meet your trustee. Creditors can appear, but rarely do. And there are essentially two things going on in Chapter 7 that debtors sometimes get confused on. One is your ability to get a discharge, and then a completely independent timeline going on at the same time is whether any assets of yours are going to be taken. Because Chapter 7 is a liquidation chapter. I don't know the exact percentages, but probably over 90% of Chapter 7s, even though it is a liquidation chapter, do not see a liquidation. And this is, again, part of the work you need to do on the front end to determine if it's a possibility. But because the main thing you need to know about Chapter 7 is you cannot dismiss voluntarily a Chapter 7 case after you file it. So you can't just dip your toe in the water. So if you think you're at risk of losing an asset, you have got to fully vet that before you file your Chapter 7 case. But essentially, you have your creditor meeting. And then if everything goes according to plan and no creditors objecting or the U.S. trustees not objecting because they think you make too much income or they think you did something fraudulent, essentially nothing bad is going on there, you're going to get a discharge about 90 days after your creditor meeting. And essentially, your creditor meeting would be the one and only court date. I'm going to venture to say 80-90% of the cases, debtors really only appear at that one court date. It might even be over 90%. If you have what we call a no asset case, meaning the trustee does not believe there's anything in an asset or that you gave away to a third party that the trustee can recoup under the bankruptcy laws, the trustee files a no asset report, you will have a case that your assets, because you have no assets that the trustee could recover, when you get your bankruptcy discharge, your case will close at the same time. And that is what typically happens in about, like I said, probably 80 plus, 90 plus % of the cases. The person just files the Chapter 7, has the one court hearing, and gets a discharge about 90 days later, and you're done with it. However, there are instances where either assets are being recouped or a creditor or the U.S. trustee is arguing for some reason against either your total discharge or a discharge of a particular debt, and you may have the case kept open for that reason. And those are the kind of cases I referenced earlier that you may also incur additional attorney's fees. So some of these you can anticipate ahead of time, particularly when you're being upfront and honest with your attorney. The attorney may tell you, look, this one creditor may bother you. They may file an objection. Or the U.S. trustee, you're really tight on the income. They may file an objection. Usually you should know this ahead of time, but this kind of thing can happen in a surprise setting, but usually you can kind of anticipate it, but then the question is, how do you deal with it? So that's typically how a Chapter 7 works. And a Chapter 13, that is a repayment plan that goes from 3 to 5 years. You are making a monthly payment to your trustee based on your income. So obviously you've got to have enough regular monthly cash flow to be able to afford this repayment plan. Unlike a Chapter 7, you do have an automatic right to dismiss. So also unlike a Chapter 7, you're not really at risk of losing any assets. So if you have a ton of home equity where you would potentially see a liquidation in Chapter 7, we don't have to worry about that in a Chapter 13. You also have your creditor meeting just like a Chapter 7 would about 5 weeks after the case is filed, but then you have a confirmation hearing about 5 weeks after that. Unlike a Chapter 7 and a Chapter 13, you have a repayment plan. You propose a repayment plan. You have to have that confirmed. Creditors can object. A trustee is assigned who can object. But if you are able to get that case confirmed, and sometimes it may take a year to get it confirmed, but your case is still active during that time and you're making your monthly payments. If you can get that case confirmed, then you keep that case plan going for the remainder of your 3 to 5 years, hopefully. Now, things can happen, substantial changes in income, those kind of things. There are just a whole variety of things that can come up during a Chapter 13 bankruptcy. And if it's substantial enough, it's going to require going to court, filing a motion. And when I refer to going to court, that's usually your attorney nowadays just doing something on Zoom. Rarely does it involve a debtor having to appear in court. But those repayment plans last 3 to 5 years, typically, although there's always an exception. Let's say you're able to pay off all your debts in 2 years, then you can be done at that point. So another thing to remember is Chapter 13s often fail for whatever reason. If they fail, you may want to convert to Chapter 7. But you may not want to. You may have an asset you would lose in Chapter 7. You may just be content to see your case dismissed. Also, you may have already filed a Chapter 7, gotten a discharge, and now are filing a Chapter 13. So you don't even need a discharge, and it's really no big deal that your case is dismissed at this point. There are so many variables that can come into play in how a Chapter 13 concludes, and just too many for me to discuss at this point. So that is Chapter 7 and Chapter 13 bankruptcy in a nutshell. And as a reminder, you can visit me online at brickslaw.com. That's BRICKSLAW.com. You can also rate or review us wherever you get your podcasts, Apple Podcasts, Stitcher, Spotify, Google Play, or wherever. And all of our contact information can be found at the link below. And for more details, you can email me personally at peter@brickslaw.com.